Hello, group. Glad to have you on here. I just got a message here. Glad to see everybody. I see Angela Yu and Dominic Signoroti, who are fellow executive board members with me, and also Marie Kwashnak, who used to be on the board, also in attendance. So welcome, everybody. One thing I did want to talk about is when we used to do these at Scott's, we used to have free meals. So we're thinking about in the future having like a Pete's Coffee gift certificate or something like that. If you think that any idea like that would be a good idea, please share that in the chat and we'll be sure to kind of look at that. Anyway, I wanted to introduce our speaker here. We're here for the top 10 issues that arise in partition cases. It's a real property practitioner's guide to partitions. The reason that we're doing it this way is this is not an introduction to partition actions. We've all been to a CLE like that before. And actually partitions are pretty simple in a lot of cases. But what happens when they get more complex? So we have here with us Jeanne Grove. She's a partner at Kaufman, Dolowich, or is it Dolowich? Dolowich and
Dolowich. Yeah.
It's a cha. Okay.
Yes.
Anyway, I'm a big fan of Jeanne's. She's got 15 plus years of real estate litigation, practicing both in Northern and Southern California. She was a 2013 recipient of the Morning Star Award, which is the State Bar and CLA Real Property Section Award for Excellence in Leadership. She's well published. It's all in the intro that was already out there, so you can check that out. She does real estate and business litigation, including HOA, co-ownership issues, purchase and sale disputes, non-disclosure claims, boundary, title, development, and construction matters. So a lot of stuff that hits home for us all. And so it is my pleasure to introduce Jeanne. If you have any questions during the presentation, please put them in the chat. We'll try to address them as we go. Thank you. Jeanne?
All right, well, thank you, John, for that lovely introduction. I will just jump right into my share screen, this lovely PowerPoint that we prepared for this. So here's our cover page, just to recap that we are going to cover the top 10 issues here that arise in partition cases. And just a little bit more background as to why I'm the one here before you speaking on partitions and how I got here. Many years ago when I started real estate law, and I've pretty much been practicing my entire career in real estate law, we handled a lot of same-sex couple disputes. And if you remember a time that same-sex marriage was not legal in our country, out here in the Bay Area, we had quite a number of same-sex couples that would purchase property together and co-own and basically live their lives as if they were married couples. And so tied to that, we handled a lot of Marvin versus Marvin claims. And then as a result, partition was the remedy if they were effectively divorcing without the probate code and the family law statutes covering them. So that's how I got started with partitions. Nowadays, of course, there are still couples, either same-sex or heterosexual couples, that still co-own properties without any prevailing written agreement. And then the other common situation are siblings who inherit properties from their deceased parents. So I would say those are the top two cases that involve partitions, though really they can be addressed in any co-ownership relationship where there is no written or contractual right to waive partition. So without further ado, just a quick background so we all have the foundation here and remember the basics. Partition, in fact, applies to both real and personal property. We are focused on the real property aspect today. And there are fundamentally three kinds of partition of real property. One is partition in kind, which is the physical division of the property into two or more distinct parcels. Partition by sale, which I'll discuss in more detail in due course, but it is in effect the most common type of partition these days, at least with urban properties. And then finally, partition by appraisal, which is a very narrowly applied type of partition because the statute is quite clear that the owners have to, in fact, agree on the partition by appraisal in order to actually proceed with that type of partition. So top 10 issues, just to set the agenda here. The first is if a partition in kind is possible anymore. And as I mentioned, partition by sale is in effect the most common type of partition these days. I'll get into why that is. But for most of you who have handled this type of case, you know that all the case law still reiterates, case law and even the statute and the legislative intent still reiterate that partition in kind, a partition by division, is still the most favored type of partition. So we will be addressing whether that's even possible anymore. Number two is, can an owner partition only a portion of the real property? We'll get to that, including the statutory basis for that. Number three is, when is an owner allowed to make a credit bid? We'll discuss the logistics behind that. Number four, are legal fees recoverable for litigating offsets issues? So as most of you probably know, the statute clearly provides the right to recover reasonable attorney's fees and other costs as part of the costs of partition. And those attorney's fees, as well as other partition costs, get divided typically based upon each owner's proportional interest in the property, which in fact means if a plaintiff is suing for partition, they can reasonably assume that they can seek to recover some of those fees as part of the partition action. So number four is really more nuanced here, and that is whether legal fees for litigating any accounting or offsets issues, not necessarily for the partition action itself, whether those fees are recoverable. Number five is, can an owner recover for a owner's waste or devaluation of property? Number six is, can one partitioning owner recover 100% of the sale proceeds if the partitioning owner paid 100% of all expenses for the property? That's a little bit exaggerated in that typically an owner will have contributed something towards ownership of the property to prevent the transaction from being illusory. But at the end of the day, the question is, how much can a partitioning owner recover? If anything, based on the amount that they are actually investing in the property, irrespective of the proportionate interest that they have title to, based on the recorded deed. Number seven is, can the issue of partition be disposed of in a motion for summary judgment? We'll get into the motion for interlocutory judgment, which you're probably familiar with if you've done partitions before. But the question is whether that motion for interlocutory judgment must be presented in the vehicle of an MSJ or MSA. Number eight is, does a lender need to be named in the partition lawsuit? CCP 872030 is the prevailing statute that we look at, which probably many of you know, we have to name all parties with recorded interests. So often this comes up. If we don't dispute the lender's interest, why do we have to name them? So we'll address that. Number nine is, what happens if one of the owners dies while the partition is pending? I have had that happen on more than one occasion. We'll address that. And finally, can an owner be forced out of the property in preparation for the partition sale? So is a partition in kind possible anymore? I think this is probably one of the most hotly contested questions in partitions that I face. In fact, right now, one case is up on appeal where the appellant, the owner who's opposing the partition, is claiming that the court, and it was Judge Schulman in San Francisco Superior Court, who decided that a partition for sale was proper. The appellant is contesting that ruling, saying that a partition in kind should have been considered and in fact should be favored in that particular action. The problem is the property in that case is a multi-unit building in San Francisco, where, as probably many of you know, San Francisco is subject to a myriad of different subdivision regulations. Condominium conversion, in a nutshell, is not an easy, straightforward process, and certainly does not happen through the partitions or court systems. Nevertheless, the appellant is contesting that ruling, and it's up on appeal as we speak. So to give you a bit of background, Cummings versus Dessel is actually a fairly recent case that addresses this very issue and recognizes that courts have historically favored partition in kind over a partition by sale. And in fact, partitions by sale have traditionally been disfavored. But notwithstanding that, we all know that courts cannot overcome the statutes such as the California Subdivision Map Act, and then if there are any local regulations, such as in San Francisco, that directly regulate subdivision of property and parcels of land. In those cases, notwithstanding a historical favor towards partition in kind and dividing properties, the reality is it simply cannot be done anymore in urban settings. So just to give you a bit of background, Butte Creek is also a really helpful case that sets out the types of evidence that the courts will look for from the parties to determine if a partition in kind is proper. First, the property has to be situated that a division into subparcels of equal value cannot be made. And there's an emphasis there as to equal value. And there's an example set out wherein a property had a well in one portion of the parcel of land that if it were to be divided, that access to the well was really the only value to the property. And the balance of the property, if it had been divided and divided away from that well and access to that well, there wouldn't be as much value or maybe little value in the balance of the land. In that case, a court could decide that division in equal parts is not possible. Again, turning back to the urban setting, one can easily assume that each of those units in a multi-unit building cannot be equally divided. Typically, an upper unit has more value than the lower unit, and there's all different characteristics in a multi-unit building that it's not so easily divided as undeveloped rural land might be. The second element is economic evidence that shows that division of the land would substantially diminish the value of each party's interest. So going back to that well example, this would be a perfect example of where if you were to subdivide that parcel of land, only the land that had the well would have any significant value. The balance of the land likely would not. So in addition to these tests, there are many situations in current urban settings, as I mentioned, that make partition in kind impossible. The Subdivision Map Act, which is a California statute, generally states that local counties are entitled to regulate the subdivision of parcels of land. In Pratt versus Adams, which is a case cited here in the middle of the slide, in fact, the two homeowners, one sued the other and they for partition, and they effectively went into the court to seek a formal subdivision of the property through that court partition process. Well, the city or county of Santa Cruz, I can't remember which one, intervened into that partition action and said, wait a minute, we have these very specific subdivision laws, and these two owners who seem to be in cahoots with each other, even though they are plaintiff and defendant in this partition action, are circumventing that set of regulations that specifically address how owners are to subdivide their parcels of land in that city or county of Santa Cruz. The court agreed with them. And of course, this is a perfect example of where if there are specific subdivision regulations that apply to a property, partition in kind is simply not possible or legal, despite any historical favoring of partition in kind. And then actually the government code, starting with 65,000, says physical division of real property in a partition action must comply with various provisions of the act. So it underscores the reality that homeowners or property owners rather cannot circumvent applicable laws that regulate subdivision of parcels. So a little bit more, just kind of expanding on the concept of whether partition in kind is even possible these days. I frankly have not seen it in an urban scenario, such as a multi-unit building. And it's even rare these days with rural land. The only concept I could think of is, and there's a case cited in one of these slides where there was a hunting lot in the wilderness, so rural. I don't think there were any applicable subdivision regulations there. And the court determined that division of that lot was possible. And similarly, in a ranch setting, if you had hundreds or thousands of acres of land that comprised a ranch, theoretically, you could divide that into equal parts. But really, aside from those rare circumstances, it is difficult to imagine a situation these days in which a partition in kind would be proper. Okay, number 2 is, can an owner partition only a portion of the real property? There is a statute, 872.830, that does contemplate that possibility. The trial court can order a partial division of the property and then a sale of the remainder, again, assuming that the partition in kind and the partition by sale, the 2 different types of partitions for each portion of the property, is supported by facts. So we can go back to the test that we talked about, where a partition in kind is proper, and assuming that's the case and the court determines that the property can be divided in equal parts, or even a portion of the property can be divided in equal parts, the court does have statutory authority to do that through a partial division of the property. And then perhaps the other part of the property can be sold. So the statute allows the court in equity to decide that. Now, the Doppelmayr case, it's probably easiest for you to just read it, but in a nutshell, it's not the best written case in my opinion, but this is the case that I mentioned with the hunting lot. And there were effectively 2 parcels of land. One what had various structures on it that were to serve the hunting purposes, apparently, of the property. And then the other portion of the property was undeveloped land, effectively for hunting. So in that case, the court decided that the hunting lot could be divided in equal parts because it was largely undeveloped. And then the portion that had the structures could be sold. Oh, I'm sorry, that is the Butte Creek case. The Doppelmayr case, by contrast, is also an example of where the court decided a portion of the property could be divided under the statute, and then also the remainder could be sold. And there's a whole convoluted reason for why they could do that. But effectively, the basis is CCP 872, 872.830. And the bottom line is the court will determine whether any portion of the property can be divided. And then if any of the portion property, assuming it cannot be divided, should be sold. The practical considerations to think about, though, these days, and that is admittedly an old case from many decades ago, it's simply not practical these days, especially when you're thinking about urban properties. So the example I laid out here is there any point to having half the lawn if the house is sold? It's just simply not practical anymore to contemplate partitioning even a portion of the property and then trying to sell the rest. Granted, there might be examples where that may occur, and like in Doppelmayr, where there was a portion of the property with structures in it and a portion that was undeveloped. That's certainly an example of where a partial division of property would apply. But other than that, I still think that this partial division is still very rare.
So Jeanne, we have a quick question here.
Yes.
So ultimately, partition in kind or partition by sale is at the discretion of the court, as long as they consider that. So these other cases like Butte and even Doppelmayr that you just referred to are possible guidelines for the court to use, but there's nothing that says you have to do in kind or you have to do by sale. Is that correct?
That's correct. There's still that historical favor towards partition in kind, but we're finding more and more these days that it's simply not practical or legal, given the very specific subdivision regulations that apply nearly statewide from county to county. So we do have, unfortunately or fortunately, depending on how you look at it, we have these slightly older cases, or at least cases that apply older law that recognize that partition in kind should still be the first option. And that's where I think a partial division of property is still a possibility, because if a court, based on the facts, concludes that at least a portion of the property can be divided, such as rural land, then it shall do so. And CCP 872.830 allows them to do just that. What my point is these days, most of the properties that we are encountering, aside from those rural undeveloped land, typically a partial division, even a partial division of property, remains impractical, if not illegal. Okay, so moving on to a credit bid, just to give you a bit of background. I frankly think a credit bid is rarely used because often, at least in the cases I handle, if there is an owner who indicates an interest in purchasing the property, that is almost always going to be preferred and will be handled through a stipulated process, rather than forcing the court to provide the notices of the sale and go through the rather protracted process, which is expensive, to go through the sale and auction similar to a foreclosure through the court process. If there's an indication that an owner wants to purchase the property, at least in our office, we typically prefer to handle that just through a stipulated transaction where we can agree on a fixed purchase sale price and handle it that way. And of course, in acknowledgement of CCP 873.630, if a buyer or one of the owners wishes to buy the property, we will absolutely recognize their right to do a credit bid. And if a property is worth $1 million and they own 50%, we're not going to say, you need to pay $1 million. We will, of course, recognize that they're entitled to that 50% share as a credit bid. But as a practical matter, just so you know, the statute does allow that credit bid to be made in the auction process. And so in effect, the buyer owner can make a bid, and if they have exceeded the highest bid by any other buyer, then they're entitled to make that bid, and the court in its discretion can grant it. And likely, more often than not, the court will grant that credit bid so long as it is in excess, either equal or in excess of the highest bid that's offered to the court. These are just some cases in case you're not familiar with the process. They're unpublished, but I think that they're helpful just for context on how a credit bid actually works. So feel free to take a look at those cases. Number 4 are legal fees recoverable in litigating offsets issues. So as I mentioned, the statute allows the cost of partition to be recovered in accordance with each owner's proportionate share to the property. And that is CCP 874. It's actually 874.040 that establishes the right to recover the cost of partition. This 874.010 lists the cost of partition, including reasonable attorney's fees. So that's where we have authority to say a plaintiff can recover its reasonable attorney's fees in bringing the partition action on the assumption that the partition action was for the common benefit. And that's the statutory language in that section. What happens, though, is often these owners dispute how much in sale proceeds that each are entitled to. And as part of that, they demand a formal accounting, or they make formal claims for offsets, such as if one owner is paying a greater share of expenses, if one owner invested more in the property, etc. And so often we are faced with the question of whether those fees, litigating the accounting, litigating the offsets, even litigating the underlying ownership shares of the property, whether any or all of those fees are recoverable. And there are no clear answers, unfortunately. We have this lovely case in 2016, the one that I mentioned here, the Voluck case, where the property was actually sold already per a partition judgment, and thereafter the parties litigated offsets, and the court decided those fees were also for the common benefit per the statute, and recognized that those fees, litigating the offsets, were recoverable. I don't know how persuasive or whether the case itself is something all courts need to follow. The reality is we, at least firsthand, when we're litigating these fees issues, they are all over the place. Some judges or referees, depending on who we have empowered to decide the issue, have decided that it can only be recoverable if the fees were incurred to, say, handle an eviction and it involved a third party proceeding. Only in those cases are the legal fees in that third party proceeding, such as an eviction of a tenant, are recoverable. I disagree that it's that narrowly applied, but we've had cases where that's the ruling. On the other hand, we have a case like Voluck, for example, where the parties litigate offsets, among other issues, accounting, etc., and the court simply says everything related to this lawsuit are recoverable, and then it's just a matter of whether all of the fees were reasonable, and it's decided on those grounds, and not necessarily that you're going to exclude certain areas of the partition action. So it's really all over the place. Obviously, we're stuck with the language that the attorney's fees must be reasonably incurred and paid for the common benefit. So the key is to argue it with those standards in mind. But really, it's hard to say whether or not offsets issues or the fees associated with litigating offsets issues are recoverable. Can an owner recover for a co-owner's waste evaluation of property? In general, CCP 732 does state that a tenant in common of real property, a co-owner, can sue the other co-owner for committing waste and actually seek treble damages. Keep in mind, because it's treble damages, you have a 1-year statute of limitations, so that can cause a wrinkle in your case, depending on the circumstances. But conceptually, there is this right to claim waste against the other owner. As a practical matter, it can be difficult to establish what the damages are for waste, but it is definitely a useful tool if, for example, one owner is effectively squatting on the property and not allowing the property to be improved in preparation for sale, or has allowed third parties to squat, whatever the situation may be. Waste is definitely a potential claim by an owner who is attempting to ready the property for sale. One option too, the Smith versus Cap Concrete was not a partition action, but it's helpful for context, where the depreciation of the market value of the property can be used to establish damages for waste under CCP 732. Okay, number 6 is, can one owner, partitioning owner, recover 100% of the sale proceeds? Yes, before I move on.
Got a couple questions here. Just wanted to throw them at you.
Yep.
The first one, one just popped up here. As to recovering attorney's fees, must the plaintiff demonstrate they made a good faith attempt to sell the property before filing a partition action?
Very good question. There's no statute that says one needs to do that, but I certainly recommend you do that. Whenever there's a basis to request reasonable attorney's fees at the end, I tend to recommend that all efforts to either resolve the case early, whatever the case may be, but especially in a partition, attempting to sell the property cooperatively, to document those efforts throughout, because it will only help you in the end if you're trying to seek your attorney's fees and you're trying to establish that they were reasonably incurred. So yes, I think that's a good best practice tip.
Okay, another question. Can a court order that the parties may utilize 1031 exchanges for their share of the proceeds? I think basically when you're selling off their portion, is a 1031 exchange allowable? I think is the question.
I think it would be allowable. There's nothing in the statute that precludes an owner from doing that. I think the only practical hurdle there is the timing of it, because if for whatever reason you're not able to complete the 1031 exchange because the court is entitled to notices before a bid can be approved, I mean, those are the only things that I would be concerned about, just the logistics of it.
Great. And then the last one is concerning waste, like attorney's fees. Do you recommend putting a demand in ahead of time for your claims for waste?
I mean, it's certainly a good best practice to have. It would depend on the circumstances, though. It doesn't hurt to show efforts to resolve a case early or resolve a particular issue early. But I think for the waste question, the more important issue is, can you establish damages? Can you establish waste in effect? And I think that's a very fact-based inquiry.
Okay, that's it for now.
All right.
Yeah.
So next question is, can one partitioning owner recover 100% of the sale proceeds? As I mentioned, somewhat of an exaggerated example, but if you think through the concept, assuming you have two owners, each with a 50% ownership share, but one owner is effectively the one running the show, paying all the property taxes and utilities, etc., and then the other owner is simply, you know, out to lunch, hasn't paid anything for 10, 20 years, other than perhaps a down payment in his or her proportionate share. They have done nothing to service the property since that time. In that example, it would depend on the accounting, obviously. I would argue that the partitioning owner, if they could prove that they in fact paid all of those expenses towards the property from day one, then one could do an accounting and back out the down payment, say it's 50% of the down payment of the other owner, and then the balance be credited to that partitioning owner through offsets. I think the way the court would rule it, though, is based on the deed, assuming it's a 50-50 split, they would assume after all expenses are paid, the net sale proceeds start out divided 50-50, and then offsets applied to that owner who bore a greater share of those expenses. I think that's how the calculations would play out and how it should play out, because the statute does say sale proceeds need to be divided in proportionate shares based on their recorded interests. But there's that right to a contribution and offsets per CCP 874.140. And it's in that context, the right to contribution and offsets, that an owner who had been paying a greater share could recover a greater than 50% share of the proceeds at the end of the day. And if that is in effect nearly all of the sale proceeds, so be it. I think it would all depend on what's calculated out in terms of how much that owner paid towards the property. This is a little bit more about that. So accounting, there's a good case on it, Kosler versus Norwood, where, oops, sorry, click too fast. Where am I? Okay. Even though the parties paid for the property in equal percentages, the court concluded there was no merit in plaintiff saying that defendant is stopped from claiming more than 1/2 interest. So in that case, it was defendant who was saying, I paid a greater share towards operating expenses, et cetera. And even though plaintiff defendant held title as joint tenants, which presumes that equal division of property, the court recognized that that defendant could make a claim for contribution and in effect collect more than his or her 50% share. Number 7, can the issue of partition be disposed of in a motion for summary judgment? The issue, the simple answer is yes, it can be, because it's disposing of a key component of the case, and it is effectively a judgment because it is an interlocutory judgment. There are several cases out there. Summers versus Superior Court right here is an example of one of many cases where the partition action was decided through a motion for summary judgment. The question is, though, must it be disposed of in a motion for summary judgment? I have frankly seen it both ways, where a party can file a simple notice motion for interlocutory judgment, and it's rather than the 75-day notice for the MSJ, it's a simple whatever day it is for a regular notice motion, right? 10 business days or something like that. The question is if that's proper, and what happens if the court decides the motion should have been filed through an MSJ rather than a regular notice motion. Is there any prejudice in the delay? Typically, a court would not deny the motion for interlocutory judgment with prejudice, but the question is, how much time have you wasted? And have you missed your deadline to file the MSJ before trial by waiting around until you got that answer on your regular notice motion for interlocutory judgment? So my suggestion is, if you can afford to wait the 75 to 80 days or whatever it is to file that MSJ, might as well do it. It's the safer vehicle and you can't go wrong filing it in that manner. And then just for context, keep in mind that the motion for interlocutory judgment statutory basis is the CCP 872.720 section. But unfortunately, in there, it does not say whether or not a party must file it through an MSJ vehicle. I just recommend that you do. There is a case out there where the court did dispose of the partition case through an MSJ. Keep in mind the Summers case that I mentioned earlier. Also, in that case, the court had decided issues of partition through an MSJ without any discussion as to whether or not the MSJ was required. But it does give us a couple of examples, at least, of cases where parties did decide to use that vehicle. Number 8, does the lender need to be named in the partition lawsuit, even if the note deed of trust is not disputed? My simple answer is yes, and the reason is CCP 872.230. That says all interests of record or actually known to the plaintiff that the plaintiff reasonably believes will be materially affected by the action must be named in the partition action. Even if the lender's interest in the property is not disputed, they should be named, and I contend that failure to name those lenders would be a demurrable issue. The tricky thing is, of course, if you are not disputing the lender's interest, you don't want to make the lender angry or in any way, or trigger some kind of breach of the note or what have you to generate unnecessary litigation with the lender. So I always suggest, if you can, notify the lender in advance and get a stipulation so that they are not required to appear or participate in any of the legal proceedings, and that you will promise to notify them of any changes, such as if there were a stipulated sale between the owners or an order to sell the property. And of course, the lender will want some confirmation in any type of stip like that, that the deed of trust and the lender will be satisfied in any sale of the property. Question?
There were a few in the question area I hadn't actually spotted, so I apologize. Some of these are late. Is there a statute of limitations for offset claims?
There isn't really, although it would depend on the nature of the claim, right? So waste would be one example where, because there's a treble damages component, I would argue that's subject to the 1-year statute. But offsets, for example, if there were 10 years of unequal payment of expenses, one could say that the claim doesn't become ripe until the property's sold. But then I have definitely seen counter arguments where they say, well, 10 years ago for sure is too long. maybe we limit the offsets to the last 2 or 4 years, depending on the claims, such as breach of contract. I don't know if there are cases out there that address that issue, but I have seen it litigated on both sides.
And then another question is have you seen where attorney's fees get 100% shifted to one of the parties in the partition action?
100% shifted. I can't imagine a situation like that because the statute says the fees need to be divided based on the proportionate shares of the owners. So, I mean, the most I've seen, and it was in a referee or arbitration setting, where the arbitrator gave our client a large share of its attorney's fees, irrespective of whether it was directly related to the partition or not. But that Voluck case is exactly like that, right? Where a judge sitting in equity in his or her discretion is simply going to say, yes, all your fees are recoverable versus only a portion.
For example, along those lines, if one of the people has paid a lot of money for attorney's fees for evictions or property management or anything like that, that may be recoverable by offset, correct?
That's correct. And to be clear, let's say you spent $20,000 trying to evict a tenant, 10,000, and let's say it's a 50-50 share, 2 owners, 10,000 would be recoverable to that party who incurred the attorney's fees, not the 20.
Right. Oh, right, because it's a portion, correct. And then we have another one. This is kind of a procedural issue. At what point do you bring the motion for attorney's fees if you're seeking them?
Typically after the partition action.
After the interlocutory judgment, correct?
At least after the interlocutory judgment, though you could reserve the right to do it after the partition action is over. It is typically a post lawsuit motion.
All right, here's a complex one I've never heard before, out from left field. Is it possible to have a contract where the co-owners agree that they have no right to partition, and then one refuses to sell or buy the other one out?
Yes, standard TIC agreements typically have the waiver partition provision. And then the second part of that was if the other owner refuses to sell.
Yeah, so yeah, possibly they have an LLC where they have joint ownership and they've waived their right to partition, but then, you know, I guess it would depend on what kind of entity they own it as. Is that right? Or, you know?
Yes, in fact, again, going back to standard TIC agreements, typically there's a waiver partition provision, and there's also separately a dispute resolution process, even in the instance of a default by an owner, if they're not paying their share of the expenses or their share of a mortgage, if they have a shared mortgage, there's a whole process typically for how one deals with a defaulting owner like that. And in that instance, there's still the waiver of partition. So partition is simply not a remedy for the non-defaulting owner in that case.
Okay, I think that's it for now. I'll turn it back over.
Okay, so we talked about, oh, did I skip? Sorry about that. Okay, lenders. So I think I talked about lenders. You must name them. Best practice is to reach out to them and minimize or avoid altogether any litigation with them. Number 9 is what happens if one of the owners dies while the partition is pending. I've had this happen at least twice, and most recently in the last year. And it's simply a motion to substitute plaintiff or defendant. The key is whoever is the successor in interest of the decedent must be established first. And if there's a probate action that needs to take place first, then that probate action needs to take place. And the most you can do with the pending partition action is to stay it pending the outcome of that probate action. And that's what happened in my most recent case, where there was a lot of squabbling over who the lawful successor in interest was for the decedent. The decedent was the plaintiff who was bringing partition. And so of course, the request was made to the court to stay the partition action so that a motion to substitute plaintiff could be properly made. And that motion to substitute plaintiff could only be made after the probate action was complete. So that's unfortunately what one has to do. The last case I had before that, we eventually settled shortly after the decedent passed. And of course that happens, but at least the logistics for substituting the party in a partition action is pretty straightforward, but it might take a long time.
Quick question here.
Yep.
Do you recommend getting either a preliminary title report on the property before filing or a litigation guarantee before filing?
You mean either or is the
Either
question?
or what's your normal process?
Okay, so first, absolutely some title report needs to be obtained. I would argue that failure to do so before one brings a partition action is malpractice. The statute clearly allows the cost of obtaining a title report as a recoverable cost for partition. And if one fails to do so, arguably you're not complying with the statute that requires all parties to be named, all persons and parties with recorded interest to be named. So that's number one. The next question, assuming this is it, whether a prelim versus a litigation guarantee report should be obtained. Best practice is to pay the extra costs. I don't think it's that much more to obtain the litigation guarantee report. And that's simply to have more certainty as to the potential named parties in your partition action. I certainly think that would be the better practice. Okay, next and final question is, can an owner be forced out of the property in preparation for the partition sale? I mentioned ouster first, just to give a little bit of foundation here. Ouster entitles each owner of a property to claim that the other owner is ousting or preventing possession of the property to the other owner. And there's case law to support that. One must prove that the other owner is in fact excluding the owner from the property. And I always suggest that be documented as much as possible before an ouster claim is made. But the bottom line is, it is a viable claim that an owner can make. And the question is, though, whether an owner who's attempting to sell the property can say that the owner who is squatting, if you will, or refusing to provide access to the property is in fact ousting that owner who is trying to prepare the property for sale. The bottom line is, if that owner who is, say, occupying the property is providing access to prepare the property for sale, I don't think that there's a basis for ouster in that case. It has to be pretty extreme for an owner to exclude and simply lock out the other owner in order to establish that. Keep in mind too, in preparation for the partition sale assumes that there's already a judgment by the court that says partition by sale must be conducted. And in those cases, this is typically where we have the ouster claim come up, is whether that one owner is not cooperative and whether that rises to the level of ouster.
So we have a few questions here. Do we have a moment for them?
Yes, definitely.
So, really good question. Do you have to name utility companies with easements on the property as interested parties?
I believe you do. Again, this goes back to the litigation guarantee report. If they're named as parties with recorded interest, you got to name them. And you can take the same approach as I recommended with lenders, reach out to them and establish that you are not disputing their recorded interests, but they are required to be named. And I believe that's a demurrable issue if they are not.
And back to your issue with like the 10 years of back expenses and things like that, is latches or some sort of non-contractual waiver an issue? Does that come up?
I mean, yes, all the time. It's a very fact-based inquiry. I have a case now where something similar like that happened, where it was roughly 10 years of expenses. But in the interim, one of the owners wrote a note to the other owner establishing what he owed as of that year. And that was about 5 years, halfway through the period in question. In that situation, of course, we have some good evidence that says, oh, he acknowledges that these are ongoing expenses that he owes to the other owner. I think that's pretty critical evidence. But barring something like that, sure, laches, waiver are definitely in play.
I've had this before. This is a good question. So let's say there's two owners. One of them has occupied the property, whether through ouster or through whatever degree, 100%, right? The other person's never been there. To what degree does the non-occupying owner have a right to rent, like equivalent value of rent for that time period? Does that make sense?
Yeah, so recovering as damages the reasonable rental value of the property, would that be the idea?
Yeah, like for example, they were 50-50 owners, they had a right to half occupancy, but the one person took it all.
Sure.
So get that, right?
Yes, I think that would be right through a contribution claim. One could say the property, because I was ousted, if you will, right, and did not have possession of the property, I'm therefore entitled to 50% of the rental value. But again, the ouster claim has to be established first. And it might be quite easy for the owner in possession to say, I never locked you out. You've always had keys. It's always been your decision to not come into this house. And in that case, I think the ouster claim has problems. I think the other angle for the non-possessing owner to take, though, is that despite the owner in possession being there, say, 10 years, they paid nothing towards the property. Right. And in fact, they should have been paying their proportionate share for the right to live there exclusively.
Right. So are you ready for a few more questions, or did you want to finish off 10? Where are we?
I think that's it. I can actually end my screen share here.
Yes.
Let's see.
Because we do have a good series. Go ahead and leave that back up. So
all
right.
Yeah, I can. Let's see, it was too quick.
How do you like to do it? If you want to put it back up so everybody has your information, because I think that's really valuable. Anyway, Jeanne, I mean, before we even get to these last questions, it's been great. I mean, really, you're hitting it out of the park. I'm really enjoying your presentation. And for me personally, as somebody who's been through, you know, a half dozen partition actions, this adds a lot of value to me for little nuances that maybe I haven't run into before. So thank you. Let me get to this. What types of situations do you see it appropriate that a referee is appointed?
Well, it's funny you say that, because the Doffelmeyer case actually addresses this. And there's a statute that says in partitions, a court shall appoint a referee to conduct the sale. Doffelmeyer strangely says shall doesn't mean shall, but it means the court can exercise its discretion to appoint a referee. And in that case, the court had concluded that it was unnecessary cost to appoint the referee because the evidence was so obvious as to what they were going to do to divide the property question. I disagree with that conclusion, and the statute says shall. So I think a referee needs to be appointed in every case, even if unfortunately it's more costly than it's worth. I think the statute is pretty plain on that point.
Yeah, I mean, most cases I've been in, we've agreed to not have a referee, just to have an agent sell it, but that does have its complications.
It does, and you're right. In a stipulated setting, you could virtually do everything, right? Obviously, you can do a partition by appraisal, and the court will not stop owners who are in agreement on a particular approach to sell the property. But barring a stipulated setting, I think the statute does require a referee be appointed.
We have it's kind of a unique question. It relates to ouster, and it has to do with not the other co-owner occupying the property 100%, but they basically moved a family member in there instead of themselves. How does that work? Does that, because they invited the invitee, that's their 100% occupancy and therefore it's a type of ouster?
I mean, it's the same facts. The only difference is it happens to be a family member. But if there's a third party who has taken possession under the premise that one owner has allowed them to stay there as a guest, then the non-consenting owner could certainly make a claim that one, they did not consent to that, and two, that there are some damages that arise from not getting equal possession to the property.
So this question is a little bit procedural. It has to do with if the co-owner is a trust, who do you name? Do you name the trustee, or do you name the beneficiaries of the trust, or all of them?
Very good question. Typically, it depends on the trust. In general, if you name the trustee to begin with, for sure, you do not have to name the beneficiaries if they do not have a recorded interest in the property and they do not have a vested interest in the property. So if you have an opportunity to look at the trust, if that's a possibility, then look at whether the trust requires that the property be distributed immediately to the beneficiary upon the settler's death. In that case, I would say likely you should name the beneficiary as a precaution.
Okay.
But if the trust says the property needs to be sold and all the proceeds divided to the various beneficiaries, in that case, the beneficiary doesn't have a right to the property. It may have right to the money after the property is sold, but that's not an interest in the property. And so in that case, I would not name the beneficiaries.
Just the trustee.
Just the trustee.
I'm not sure I understand this question. It's posed by Jim Straw, who I've known a long time. He was my former boss. He says that what if there's a court-ordered sale of residential property and one of the co-tenants refuses to fill out or sign a TDS, transfer disclosure statement? What do you recommend in that kind of circumstance?
Well, first, I don't really see the need to complete the TDS in most cases if there's a referee appointed, because basically the referee takes over for the owners. And so the owners really don't have much involvement in conducting the sale itself. So I would argue that a TDS is not even legally required in a court-ordered sale. But if you do encounter an issue where an owner is supposed to sign something, so the more common case is if that owner is supposed to sign the deed, delivering the property to the buyer, the lawful buyer, unfortunately, you need a court order compelling that.
Right. So a lot of times when you have a referee and they're signing on behalf of right, the court has to approve the grant deed. Is that right?
I don't think the court has to approve the grant deed, but it has to approve the sale. And it will often give a lot of discretion to the referee if the referee approves or proposes one buyer be accepted.
That's right. Can the ousted owner recover mortgage payments made during their time of non-occupancy?
Yes, assuming ouster is established, that is definitely an element of damages that one could claim, I would argue.
Sorry, I'm trying to. Oh, have you ever seen a partition where the referee's actions were challenged?
Yes. I mean, imagine this is real estate divorce, right? So that's what I call it. So of course, if you have owners in dispute, actually, I had a case where the two owners were at extreme polar opposites of each other and squabbled over everything. But ironically, they agreed on firing the referee. And this case is so long ago, I can't even remember why they both hated the referee, my client and the other owner, but they actually jointly together sought to remove the referee and his referee.
I like
so
it.
It can happen.
We got a new question, and I really like this one. Can I think he wrote assumption, but I think presumption of equal percentage interest on title be rebutted based on differential capital contribution? Want me to repeat that?
Yes, please.
Can the presumption, I think it's the presumption of title, of equal percentage interest, like 50-50 owners, on title be rebutted based on differential capital contribution? One put a bigger down payment down than the other.
Yeah, absolutely. All the time. That's when you litigate ownership interests, of course. It depends on the contributions of each owner. Keep in mind, though, the deed, I mean, as mentioned in the question, the presumption is, of course, there. So the party who's attempting to overcome that presumption has a pretty high burden, but it can be done.
All right, Jeanne, they keep coming in. They're good.
Oh, boy.
Yeah. Okay, so the question really has to do with what is an interlocutory judgment? And like, for example, can they appoint a referee, deal with offsets, deal with the other relief right at that stage? Or is there some sort of differential with how all of these issues are decided generally in a partition action?
The court can award or rule on all of those things, referee, manner of partition, all of those things. But the statute for interlocutory judgment really requires two things: the ownership interest and the right to partition. And then the manner of partition can be ruled theoretically after. And then, of course, as part of that, whether a referee should be appointed and who.
Okay, but normally it would be the right to partition, the manner of partition, and the referee issue.
Yes.
Someone's going to get right. It's normally that way, right?
Well, right. So in the most recent case I had, we were granted an interlocutory judgment where the ownership interests they weren't in dispute anyway. So it was 50-50. And
Okay.
then the court ruled partition by sale.
Right.
But they left it to a pretty belabored meet and confer process between attorneys to decide on a referee. And then we were entitled to brief if we couldn't agree on the selection of a referee. So that piece, the appointment of a referee, can be ruled on at a later date.
Okay. To what degree do if there's a referee appointed, to what degrees do the parties, I'll just kind of summarize the question. To what degree do the parties have the right to manage or micromanage the referee, like see all the offers coming in, say yay or nay and all that kind of thing? How's all that decided?
Well, the court can, in its discretion, instruct the referee to report to the owners. But as a practical matter, it's very difficult for owners to micromanage the referee, because the vehicle for doing that is to file a motion with the court to ask for instructions or to order the referee to do this or that. So that takes time. It costs money to file the motion. And who knows what the referee's doing in the interim, because typically they're working on preparing the property for sale, et cetera.
I'm not sure about this question. If the parties stipulate to a settlement prior to trial, I guess that's before an interlocutory judgment, can the prevailing party, in terms of who gets the property, later file a motion for attorney's fees incurred for getting the settlement?
It depends what your stipulation says, right?
Right. The settlement, yeah.
Right. If there's a 1542 release, Civil Code 1542, then theoretically you've foreclosed the right to seek attorney's fees.
Good question. Does the proposed sale always have to result in an auction process in court?
That is a good question. It's either a private or public sale. And the private sale, there's been some question about that actually, as to whether private simply means a bid among owners. And that's not quite right. A private sale still requires notice. There's a whole statutory process where you provide notice and then people basically get to bid on the property, similar to a foreclosure. A public sale, I argue, is when you list it on the open market. And that's typically when you have a referee who actually gets to decide, with the court's approval, on hiring a broker to market the property.
Have you ever seen where the court rejected the referee's actions or proposals or anything like that?
Again, going back to that example where the two dueling owners sought to remove the referee, it was because it was a distressed property and both owners felt that the referees was simply getting frustrated and wanted to just be done with the project and was willing to accept the first offer that came by. And of course, these two owners had sentimental attachment to the property and felt that it could be improved for the betterment of both. And so in that case, the court did question the referee's motivations as to whether they were really doing the best they could do to sell the property for the best price.
I'm not sure I understand this last question, but it goes to, do you have to be a title owner to assert partition, or could you be an equitable owner?
That's a very good question too. I think you and I talked about a case in which I represented a woman who gave a large amount of money to her family members, cousins. She wasn't very sophisticated and obviously, and did not ensure that she was on title, but she was very good at documenting her expenses. It wasn't as if she paid them in cash, but it was paid through checks and other documented methods, but she was never put on title in exchange for her contribution to the down payment, and then her without fail monthly contribution to mortgage and other expenses for a long period of time. I can't remember how long it was, but over 5 years for sure. In that case, we were able to assert an equitable interest on her behalf in order to force a partition sale. We never got a dispositive ruling on it because we were eventually able to settle. But my opinion is, of course, both sides lawyered up. I think we were able to convince the other side that we had a large amount of evidence to support our equitable ownership claim to really contend with for a partition action.
So more like a constructive trust in that case. You just were allowed to assert the partition action in that case. You never
That's
got
right.
a decision on that.
Never, and although I do recall we were able to survive a demur at least. And I think that was the most telling part, and what changed the settlement posture of the other side is that the court decided that is not something to be dismissed at the outset, that if we are able to make a threshold claim that we have ownership rights to the property, irrespective of what's on title, that's enough to go forward on the partition action.
Okay. No, I think I do understand the question better. I've reviewed it a few times since then. And so it wasn't equitable interest. What if it was an executory interest? I think I pronounced that correctly. Sorry if I pronounced that incorrectly. But it's basically an agreement to sell the property. So you basically have a contract to buy property. So basically a specific performance type thing where
in that case, though, one could just file a breach of contract lawsuit, right? And request specific performance.
Well, anyway, that was posed by my colleague, Dan Mueller, and I apologize, Dan, if I got that one wrong, but I tried my best. Anyway, that's all the questions we have. Oh, wait, one more. Sorry, I see it here. Do you recommend waiving the overbid procedure?
That's a good question. This goes to credit bids. I may have failed to mention, in a credit bid situation, the buyer, to be entitled to the credit bid under the statute, must show 10% or more than the best bid offered by a third-party buyer. So does one recommend waiving the overbid procedure? I'm not really sure in what circumstance that would happen. As I mentioned, if a buyer has expressed interest and the ability to buy out the property, I typically recommend we handle that through a stipulated process rather than go through the rigmarole of a court-ordered credit bidding and the whole private sale procedure. So in that case, sure, I do recommend waiving the overbid procedure.
All right, can you see the Q&A in there?
I think so. I saw that question at least.
Dan, Marie says that's fine, but Dan's reposed his question again. Have you seen a partition action involved as a threshold issue or question the validity or enforceability of the underlying agreement by which one of the owners purportedly obtained from the other a supposed part interest? So again, it's like an executory contract where, hey, I'm going to give you 50% of my property. And so I guess the court first deciding whether the agreement is void or voidable, thereby possibly resulting in significantly reducing, eliminating the second owner's interest or award.
I see. So it would depend on the underlying agreement in question. Again, if it's a type of agreement that that plans to grant property sometime in the future in exchange for some consideration, I would just say that's regular breach of contract action. But I don't think that you have an equitable right to the property yet unless there's a breach.
Right.
So I guess that's assuming there's some agreement and it's been satisfied by the non-breaching party, and then the breaching party refuses to give title or a portion of the property, then yes, I would say you could make a claim to enforce that ownership right.
Right.
In court. But that's not really a partition. A partition is more you're attempting to divide the property or sell the property or do something with your property.
Right.
It's not really executory contracts that are at issue.
Yeah, I would tend to agree with you there. Well, anyway, I mean, lots of great feedback here, Jeanne, and look, Anne's back. By the way, I want to thank Anne Wolf for, I don't know how many years I've been part of the Contra Costa Bar Association, but you've always been here, and like, this place would not work without you. She works like clockwork. She's so organized. She keeps us all in order. And so thank you, Anne, for all the work that you do. But thank you, Jeanne, especially you, Jeanne.
Did a great job
today.
Thank
So
you.
really, thank you for coming
having
by.
me.
Thank you, JR. Thank you very much, Jeanne. And I wanted to let everybody know, in case you didn't see it in the chat, that materials and attendance certificates will be sent out in the next few days. So do not fret. And that's all we have for today. Thank you very much for joining us, everyone.
Thank you, everybody.
Thanks.
Have a great weekend.